And let's bring in Mitchell Epner. He is a former federal prosecutor for the District of New Jersey. Mitchell, thanks for joining us.
Thank you for having me, Roger.
Your reaction to what we're hearing from the jury, is this unusual for them to say they've got some verdicts, but not all?
So it is unusual that they have said this. It's unusual also that they've said this quickly. This jury's been out for less than 2 days. That is a very short period of time for jurors to tell the judge that they are deadlocked as to one of the counts.
What might be driving that, do you think?
So I think that the defense made a bunch of arguments with regard to the RICO charge, which is the count that they're deadlocked on, which is a very technical law that has a lot of requirements. And the defense may have been successful in convincing at least one of the jurors that the government didn't reach its burden of proof with regard to those technical aspects. If I were the defense, I would be very, very, very concerned that the verdicts on the sex trafficking and the interstate travel for purposes of prostitution charges are likely to be convictions. But that prediction is worth exactly the amount that you paid for.
And for these jurors, I mean, they've been in this trial, how long is it now? It's over 2 months, I believe, right? Have they started to make their decisions already, or do they keep fairly open-minded, does it feel, before they head into their deliberations?
So they're instructed to keep an open mind until they head into their deliberations. But in my more than 30 years of experience as a trial lawyer in the United States, most jurors start making up their minds as early as opening statements. And here we had yesterday a note that one of the jurors was suspected of being incapable of deliberating. So it seems very clear that at least one of the jurors has a very strongly held belief about at least one of the counts.
Does this open it up to an appeal, or could there be a mistrial or anything like that?
So the judge does have the ability, if he decides to eventually take a partial verdict, and that happens frequently. It is also possible that the judge will try to see if the jurors will reach a verdict as to the remaining count. Anything that happens in this case certainly will be appealed, but taking a partial verdict would not be a particularly fruitful avenue for appeal.
And we've had both the prosecution and the defense pushing, saying that they want the jury to continue. Is that who is that better for?
So both sides want the jury to continue to deliberate, but the prosecution has asked the judge to issue something called the Allen charge, which formally tells the jurors that they should continue to deliberate, and each side in the jury room should strongly consider the views of the other side. And it ordinarily is considered a way to try to get a holdout juror to give up their position. The defense does not want that. The defense, I think, believes that the holdout juror is on their side, not on the prosecution side, that it's split against them, not for them. So they're just asking the judge to say, just continue to deliberate without giving the formal Allen charge, which goes through the idea that each side should strongly take into consideration the views of the other side.
Okay, Mitchell, thank you for your insight. We appreciate it.
Thank you.
Mitchell Epner is a former federal prosecutor for the District of New Jersey.